So after the National Environment and Planning Agency, NEPA, had entered into a secret deal with a company that had polluted the Rio Cobre, Director of Public Prosecutions, Paula Llewelyn, has now come out and say her office take over all of the environmental pollution cases that NEPA had. She has criticized everybody involved, said they never know what they might do. I'm going to be walking you through what happened. Thank you so much for joining me. I'm Dion Jackson Miller. This is Courtside, and it's time for tea. So if you watched my first video on the NEPA secret deal, I'll link it below and at the end of the video as well, you'll know that I'd been critical along with many other people of the secret deal that NEPA entered into. Now what happened is that NEPA was prosecuting this environmental pollution case involving the Rio Cobre, and one day perhaps NEPA come to court and say they're not going ahead with the prosecution because they've entered into an agreement with the company. Then them say, is a secret deal. In other words, there was an agreement they entered into that had a non-disclosure clause, meaning the two parties can't say what they agreed to. Well, people start to rail up on cuss because, what is that at all? And then the minister who has responsibility for the environment, Matthew Samoda, said not a hell, and he instructed the deal to be made public after, of course, the company had agreed, because both parties had agreed to the secret deal, so both parties would have to agree to go public. Now the Director of Public Prosecutions, Paula Llewelyn, has come out and said everybody involved with the matter messed up. None of them know what they might do. Now, of course, the ever diplomatic DPP never used that language, but we can read between the lines and we can see through diplomatic language. Not true. And I have to say it was an excellent statement, an excellent analysis of the issues and a discussion of what happened and what should have happened. And in her entire statement, she put the public interest at the center of the discussion, which did not happen with the secret deal. I have to say though, this is really a huge black eye for NEPA, and what it says is that they can't be trusted to prosecute environmental matters. So look what the DPP said. She said, I have revoked the general fiat, that is, permission to associate with the prosecution of a matter that general fiat had previously been granted to NEPA / NRCA, Natural Resources Conservation Authority. So because NEPA had this general fiat, they were allowed to prosecute environmental matters because after all, as the environmental regulator, they're the expert on the matter, right? Except the trade winds matter, the secret deal, and the public outrage that followed once news broke about the secret deal. So the DPP said, going forward, the legal officers of NEPA may apply to watch proceedings in these cases or make an application for a fiat which will be assessed on a case-by-case basis. So she's saying they can come court if they want, and they can watch the prosecutors from the DPP's office work, or they can apply for a fiat on a case-by-case basis, which of course may or may not be granted, and even if it is granted, they would still have to be working with the prosecutors from the DPP's office. In fact, the DPP says she's already taken over all 7 of the environmental cases that NEPA had dealing with, and her lawyers are already now dealing with those. She also says she's going to draft a policy to set out how the clerk of court should operate when a lawyer comes to court to prosecute a matter with a fiat from the Director of Public Prosecutions. Now, the clerk of court is a prosecutor in the parish court but doesn't answer to the DPP. They answer administratively to the judges. So she's saying them never know what they might do either. She says it was unfortunate that the parties to the settlement agreement, NEPA and Tradewinds, lacked the awareness that given the high public interest in this matter and the circumstances, that perhaps a mediation agreement, including a non-disclosure agreement, was perhaps not the most prudent or appropriate course of action to adopt. I hear that and I have to say, duh. How did I know that? She then says it was even more unfortunate that the court, meaning the judge and the clerk of the court, did not scrutinize or interrogate the matter more fulsomely, or at the very least allow some time for the Office of Director of Public Prosecutions to intervene. She said non-disclosure agreements are not a part of criminal practice and procedure, and that this course of action was not only capable of undermining the public's confidence in NEPA's capabilities to enforce accountability on the part of perpetrators, but that in fact it did so undermine the public's confidence. So you see what I mean? She's saying nobody never know what they might do, neither the judge nor the clerk of the court nor NEPA nor Tradewinds. And really and truly, I still have no answer for the question as to how a government agency that is prosecuting an environmental matter could think it's okay to enter into a non-disclosure agreement with the company that did the pollution and thinks that they can really turn to the public and say this is a secret agreement. I still have no answer for how it is NEPA thought that would fly. She said, based on the circumstances of the case, for there to have been accountability via a plea of guilty by the company, and thereafter any remedial efforts already made by the company be directed towards mitigation and sentencing. What that is saying is that yes, the company should have just pleaded guilty, then they could come to court when it's time for sentencing and say, look, judge, look how much money we spent, look how much time we spent cleaning up and trying to make sure this doesn't happen again. And the judge then could take that into account in perhaps imposing a lighter sentence than would otherwise have been imposed. She said a formal plea negotiation would have been the more appropriate modality. Both the prosecution and defense would have been able to come to a mutually agreed provision, and this would have been subject to the approval of the judge, who could either accept it or reject it if it did not meet the interest of justice for either side. And she said, it's my view that given the high public interest and the subject matter being an environmental breach, it would have been in the public's interest for the contents of the agreement to be made available to the public through the court. So she's saying again that a non-disclosure agreement has no place in a criminal prosecution, that it should have been a plea negotiation. Both sides agreed to something that would have been subject to the approval of the judge. And she's saying the judge then should have made that plea negotiation public. So all of that makes perfect sense, right? But it was kind of embarrassing for NEPA, or more than kind. I think very embarrassing for NEPA, but also embarrassing for the judge, because like I said, the DPP is also saying the judge should have done something different. So the judiciary sent out their own statement, basically saying, Madam DPP, we no work for you. Don't believe me? Look at their words. A trial judge is under no legal duty to question or override a prosecutor's decision not to proceed with a criminal matter. There is no legal or factual basis to support the suggestion that the judge should have interrogated the matter or facilitated consultation with the Office of Director of Public Prosecution. The judiciary does not operate as an agent of the Office of Director of Public Prosecution, even in matters where fiat has been issued. Like I said, we don't work for you. The DPP responded saying basically judges are not robots, and if they see foolishness are going on in a courtroom, they need to say something. She actually said this in an interview with me. She said while acknowledging that a judge cannot override a decision to end a case, they should still ask questions in terms of what is happening in the interest of transparency. She said the court cannot sit there like an automaton. In the meantime, she says her office has already got a guilty plea from a company in an environmental pollution case. The company was fined the maximum allowed at the time, which was 50,000 Jamaican dollars. Okay, yes, I know it sounds a little bit, but the fine has since been increased to a maximum $5 million or 5 years in prison. She says her office is going to work with NEPA lawyers and train them up and allow them to shadow the prosecutors of her office and appear in court with guidance from them. So basically, the DPP has validated every single concern and criticism that was raised by advocacy groups when the secret deal came out. Also validated the concerns raised by members of the public. I thought this was a very thorough and comprehensive statement. I thought it was well thought out, and it paid a lot of attention to the critical issue of the public interest, which a secret deal did not. The fact that the DPP didn't hesitate to drop lawyers from another government entity for violating the public trust, because that's what it was, I think it means this particular episode ended as well as it could have. We're certainly going to be watching to see what happens from here, what happens with the other environmental cases that the Office of Director of Public Prosecutions is now dealing with, and I'll make sure I bring you up to date on that. Alright, gonna have to leave it there. Thanks as always for watching. Remember, like the video, share with somebody you think might be interested, subscribe if you haven't done so yet, and of course click that notification button to make sure you know anytime I drop a new video. I'm Dion. Thank you so much for watching. Time to go back to my tea.